Well, I don't think Rule 1.1 requires lawyers to become technological experts in any particular vein. And it doesn't mean that a lawyer can't prefer to work out a cross-examination on a legal pad. Sometimes I like to do that. Sometimes I like to go back to writing things down for myself.
I'm Chad Main, and this is Technically Legal, a podcast about the intersection of technology and the practice of law. Each week we'll talk to a mover and shaker from the legal and technology fields. We'll learn a little bit about them, what they've been up to, and hopefully get a couple real-world tips that lawyers can use to integrate technology into their legal practices. In this episode, we talked to Jim Doppke. He's a Chicago-based ethics attorney with the Robinson Law Group. Before that, he was a prosecutor for the Illinois Attorney Registration and Disciplinary Commission. We talked to Jim about several topics, but one of the main things we talked to him about are changes to Model Rule Professional Conduct 1.1, which now suggests that not only must attorneys keep up on changes in the law, they must also keep up on changes in technology that impacts the practice of law. When you talk to people about different kind of lawyers, being an ethics attorney probably isn't top of their list. So we asked Jim, how does one become an ethics attorney?
Well, first of all, if you're running into an ethics attorney every day, you're either in my firm or you're doing something wrong. But I became an ethics attorney by reading a lot of Aristotle. No. Really what it was, I was a legal aid attorney working in an office in Joliet, and I was looking at the Law Bulletin classified ads one day and saw that there was a staff counsel position open at the ARDC. And I went out for it, and I had a sense that it was going to be an interesting job, and I was right. But it was perfect for me and what I wanted to do right then. It gave me a real breadth of experience right off the bat. Gave me really good trial experience right off the bat. I had been in practice for, as I say, about 3.5 years or so, and I felt like I could just hit the ground running with what I needed to do, which was investigate and prosecute attorney misconduct. That was my job there. So I worked on investigations during their confidential stages, took sworn statements of lawyers to try to find out what was going on, lawyers and non-lawyers. And then when formal charges were authorized, I prosecuted those cases.
So how long were you at the ARDC?
14 and a half years.
And now you're private practice with the Robinson Law Group?
Correct. I am of counsel to the Robinson Law Group, the Robinson being Mary Robinson, who was the administrator of the ARDC when I was hired there. She began there as administrator in 1992 and was there until, I think, early 2007. We're a small 3-person firm, and we concentrate our practice in defensive disciplinary matters primarily, although we do handle other matters relating to professional responsibility and legal ethics. But we do represent lawyers and sometimes non-lawyers or not yet lawyers in other professional proceedings. We sometimes represent candidates for admission to the Illinois bar who have issues that have been flagged by the Character and Fitness Committee for further investigation, and sometimes as a means to bar them from admission at this point. And sometimes those proceedings involve contested hearings. The proceedings of the Character and Fitness Committee don't always involve that, and they don't always admit of attorney participation, but they do when it becomes a contested matter, and that's a hearing done before a panel of 5 lawyers. Sometimes we even represent non-lawyers who are coming into contact with the ARDC through its enforcement of unauthorized practice of law rules and principles. There are lawyers who work for the ARDC whose job it is to investigate allegations that non-lawyers are engaging in the unauthorized practice of law. And those can sometimes involve contested proceedings as well. But we sometimes have consultations with non-lawyer clients about those kinds of proceedings. But more typically, those matters involve some level of investigation and some level of admonition by the ARDC that this non-lawyer should simply stop doing whatever it is they're doing, and move along to something else. And often that does happen. So those are some of the kinds of matters that we handle and the phases in which we handle them. But mostly, day to day, I'm helping lawyers through what can be difficult re-examinations of their past conduct. Let's put it that way.
But you also counsel attorneys who aren't in trouble, may just have ethical questions. That's how you and I met. When I launched my document review business, I came to you and wanted to know, as my responsibilities as a lawyer, I was getting out of the practice at the time, just to make sure what I was doing was on the up and the up. You do that kind of work too, right?
That's true. And that's actually some of my favorite and the most rewarding work that I've done. There's something very exciting about being able to look with a client forward to something and help them build either a business like you did, or a different business model for their law practice, or to help them do something as simple or seemingly simple as craft text for an advertisement, or think of a new way to market a particular practice to a certain sector of clients or potential clients.
Despite the popularity of lawyer jokes,
I think he needs a good lawyer. And do you know what you call a lawyer that's gone bad?
What?
Senator.
Oh, okay.
not that many attorneys get in trouble with their respective disciplinary commissions. So the process of attorney discipline is somewhat shrouded in mystery. Jim explained the procedures and tried to dispel some of the mysteries surrounding them.
The ARDC takes in about around 6,000 requests for investigation per year. And these are the beginning stages of investigations, and they are confidential then, and they remain confidential until just after formal charges are filed. And they come in many different ways. Sometimes it's somebody really just scrawling out a complaint on a piece of paper. Other times it's lawyers complaining about other lawyers, which in some situations in Illinois they have an obligation to do, and in other situations they do because they think they have an obligation or because they simply want an investigation to occur. Sometimes judges would report things to the ARDC, and sometimes the administrator's office itself, that is the office in which I worked, would pick up on attorney conduct issues from the media, newspapers or the internet or something. It would just become, you'd become aware of an indictment, for example, or just some other news story and open an investigation. We had the authority to do that and sometimes did.
Interesting. So in this day and age, and this is a tech-related podcast, social media, did they ever monitor that, or were they monitoring that when you left?
Not in any organized way that I know of, and when I started there, it wasn't a thing. But they're aware of it, and they're aware acutely of social media issues affecting the profession. They had a case several years ago that got attention nationally that involved a lawyer's blog and confidentiality issues that the lawyer ran into and didn't handle correctly, and they prosecuted that and obtained, I think, by consent, a suspension in that case. So they're aware of the lawyers' presences on social media, but they're not the FBI or any agency like that, and they don't have any organized monitoring program. But if they're looking at a lawyer and they need to learn something about the lawyer, they'll use the internet to do it.
So they're not using Hootsuite to monitor their lawyers' Twitter feeds?
I doubt it.
Yeah. So you mentioned a couple of things. It sounds like there's different stages in the attorney grievance process. Everything's confidential, but you said ultimately it culminates in a formal charge? Is it? It
can, yes. And the number of those has been declining over the last several years. It used to be that you could say that out of the 6,000 investigation requests, about 100 to 120 would ultimately result in formal disciplinary charges. Now that number is down around in the 80s or sometimes even in the 70s. So that arises only after the investigation is completed. The matter is referred to a body within the system called the Inquiry Board, which functions kind of like a grand jury in the criminal system. It's a panel made up of 2 lawyers and 1 non-lawyer who vote on whether formal disciplinary proceedings are required in any given case that is presented to them. And sometimes they vote that formal disciplinary charges are not warranted for whatever reason. And they can close investigations. They can continue them to monitor an attorney's compliance with almost probationary conditions like substance abuse treatment or something like that. And in those stages, the matter remains a confidential investigation. But if they authorize formal charges to be filed, the administrator files those before the hearing board of the commission, which is like the trial level of the system. And just after being served with the complaint, just after the attorney is served with the complaint, those charges do become public.
So the steps would be a letter comes in or some notice to the ARDC comes in. They investigate it. If they think it warrants taking it to the next level, it goes to this body. Then they decide whether or not the formal charges will be pursued.
Correct. And the attorney will know about the stages of the investigation. Very often at the outset, the attorney is asked by the ARDC to provide a letter response. And in my work now, we assist lawyers in writing those response letters, and it's an important thing to do. It sets out the lawyer's side of the story at a very early stage. And you can forward to the ARDC whatever paperwork, and should forward to them whatever paperwork supports your position. And many, many investigations are closed shortly after that because the lawyer has explained whatever needed to be explained. The client was confused about something, or the person complaining was confused about something, and the lawyer explains it, and there's no further action that needs to be taken. But if the matter is more complex, or if it involves, let's say, the lawyer's misuse of funds, the matter is going to progress from there. And the ARDC, again, will frequently go back to the lawyer with requests for further information. If it's a money case, they'll ask for bank records and other records of the lawyer's practice. And the lawyer will have the opportunity to provide those, and really must provide them, because the lawyer has a duty to cooperate with the ARDC. It's also in the lawyer's best interest to do it. But the ARDC can also issue subpoenas during that time, and the lawyer may or may not know about it. The ARDC doesn't give notice, but lawyers often find out from their banks and so forth. But the lawyer knows that the investigation is progressing, and it does remain confidential up until the reference to the inquiry board remains confidential. It's after the inquiry board decides that formal charges can be filed that the matter becomes public.
And then once the formal charges are filed, does it proceed like general civil litigation, where you have a discovery phase, you have a trial, you have a verdict?
More or less, yes. It does proceed according to the Illinois Code of Civil Procedure. There are also special rules that commission litigation proceeds by that have some twists and turns, and that are not like regular civil litigation. For example, there are no written interrogatories. There used to be dispositive motions to dismiss, motions to strike, motions for summary judgment. Now there's a rule that specifically disallows those motions. So if the matter is contested in any way, it's going to hearing. And when I say hearing, that's a proceeding that's more like a civil trial than just about anything else. It's not really an arbitration hearing or something of that nature. It is different in the sense that it's before a panel of two lawyers and one non-lawyer, once again. And these are different people than are on the inquiry board. They're volunteers. They hear the cases. Many of them have been volunteers in the system for a long time. And they're experienced in hearing the testimony that's adduced and making determinations about whether there's clear and convincing evidence of misconduct. That's the evidentiary standard. But it does proceed according to normal civil trial rules and normal rules of evidence here in Illinois, including recently there was an expansion of the kind of character evidence that can be provided. It used to be that character evidence in our cases, in lawyer discipline cases, was limited to testimony about the reputation of the lawyer for truth and veracity. But now with an expansion in Illinois in general of character evidence, the lawyers can offer more expansive testimony about their own character, what they're like as a person, but also what they're like as a lawyer and their professional skill level and things like that. So you hear evidence like that being presented in hearings as well. The decision about whether the lawyer engaged in misconduct is a bifurcated decision. The panel will first, if they determine that the misconduct was clearly and convincingly proved, will enter a finding that the lawyer did engage in misconduct. Then they have the opportunity to consider, and only after they enter that finding do they have the opportunity to consider whether the lawyer has been previously disciplined. That fact doesn't come into play until after the finding of misconduct is made. And they take that into account when determining what the sanction recommendation should be. And the sanction recommendation can be anywhere from a reprimand, which is the lowest level of disciplinary sanction and which doesn't go to the Illinois Supreme Court, except in the very rarest of cases, all the way up to a recommendation of disbarment, which is effectively an indefinite suspension from the practice of law.
In the last couple years, you'd be hard-pressed to pick up a legal technology publication and not find an article about how the robots are going to take over, replace paralegals, take associates' jobs, and just otherwise make the lawyer's job obsolete. Some of this furor is somewhat motivated by changes to comments to Model Rule Professional Conduct 1.1. Under these changes to the comments to Rule 1.1, attorneys are also obligated to stay abreast of changes in technology. That might be easier said than done, so we asked Jim, what does it really mean to stay abreast of changes in legal technology?
Rule 1.1 deals with attorneys' competence, as you mentioned, and always has. And then the definition of competence in the rule has always and still encompasses the concept of the lawyer bringing to a representation the requisite level of skill, thoroughness, and preparation. Now, it occurred to me as I was thinking about it, those three things are different, and especially skill. Skill is kind of the outlier there, because skill is intended, I always thought, to mean something that you, the lawyer, bring to the situation. It's something you already have. I mentioned before applying my ARDC experience to consulting with clients, and that's I hope the level of my skill that I built up over those years at the ARDC. I have skills in some of those areas, and I bring them to bear on what I do now. But thoroughness and preparation can be things that you bring with you, but it's really something that you do as you go. It's something that that those are goals that you have as you go through a representation, to do it thoroughly and to prepare thoroughly for whatever it is that's coming your way and the client's way. So those are the ongoing obligations, and I think that really gets to the heart of what Rule 1.1 requires of lawyers. Ongoing skill and ongoing thoroughness and ongoing preparation. And so the change that we've heard about in recent years, first of all, isn't a change to the text of the actual rule. It's a change in the comments. And actually in Illinois, we didn't even have comments to our rules until 2010. But we have them now after the rules were modified to resemble more closely the model rules. And the comments, our comments now typically track the model rule comments, and they do when they change many times, and they have with the comment to Rule 1.1, which is Comment 8, and it again doesn't really require anything different. It's not an additional obligation that lawyers must meet. It's rather a change in emphasis or an emphasizing of the continuing duty to keep abreast of developments in technology and how they affect the law and how they affect your representation of clients. And again, that's not really that different from the heart of Rule 1.1 as it's always been, because it emphasizes that ongoing nature of your thoroughness and your preparation. What the comment now means is that your thoroughness and preparation should include familiarity with new and ongoing technological tools that could help your client that could be used to help your client avoid problems. So the rule really is not requiring but encouraging technological adeptness is what I would say. And that can mean that you have a skill in technology or that you have an ongoing willingness and openness to learn about new technologies. I think that's what the change was to emphasize that as an ongoing component of competence for lawyers.
You mentioned, and I like the way you phrased that, technological adeptness. So if you have a spectrum, on one hand you got Luddite, who knows nothing about technology, head in the sand, and on the other hand you got somebody that can code, a developer. So where in that spectrum do you think Rule 1.1, the obligations of Rule 1.1 fit?
Well, I don't think Rule 1.1 requires lawyers to become technological experts in any particular vein. And it it doesn't mean that a lawyer can't prefer to work out a cross-examination on a legal pad. Sometimes I like to do that. Sometimes I like to go back to writing things down for myself. And Rule 1.1 doesn't mean you can't do that anymore and you have to type everything out on Microsoft Word or something. Well, and nor does it mean you have to reinvent the wheel, though, every time. And that's really what I think it militates against, is a lawyer going into a representation or continuing a representation without having researched what the best technological tools are to help with that representation. And that can mean anything from technological tools for the lawyer's own systems, using a case management system for the lawyer's benefit that will ultimately devolve to the client's benefit as well, or specific technology to apply to the client's problem at hand. And I'm thinking here the kind of work that you do, for example, with e-discovery. If a lawyer goes into a complex and contested litigation matter without knowing the e-discovery dimensions of that case or the tools that are available to deal with those dimensions, that becomes a competence problem under Rule 1.1. Now, I have to say, as I say that, is it a competence problem that is going to subject the lawyer to a formal charge of misconduct? In Illinois, probably not, or it may not. That is, you don't see the ARDC in its formal proceedings charging violations of Rule 1.1 all that much. But a struggle with for example, again, the e-discovery dimensions of a case and ability to deal with the scope of those dimensions because of a lack of understanding of technology could lead to other ethical violations, because the lawyer could be overwhelmed by the e-discovery things that they don't know about. If they don't know the software and they don't know the people to reach out to for help, they could become overwhelmed by everything that they then have to do, and they can't cope with that, and then they start making other mistakes or making bad choices.
Knowing that attorneys in at least 25 states are obligated to stay up with legal technology, I asked Jim, where can lawyers start to learn more about tech and maybe get a little more comfortable about using technology in their practices? He had some good ideas.
Well, again, there's no one way to do it, and the rule doesn't mandate that you drop everything and learn about all the newest technology right away. There's no way to do that. I'm overwhelmed a lot of the time by technology. I like to think I'm versed enough in the technology that I need for my practice and that my clients need me to understand. But sometimes when I find that I'm hearing about something that was out a few months ago and that could have been helpful back then, or even longer ago than that, and I was behind the curve. So you can't catch yourself up, and the rules don't expect you to catch yourself up immediately on everything or to become an expert in everything. But what my suggestions are start with CLEs about law practice management and technology and the combination of the two.
And some states are starting to mandate legal technology as part of the CLE requirements, just as states require ethic classes, substance abuse classes. Florida, I think, is the one that comes to mind.
Right. I was just going to say Florida has done that recently. That has broken out technology as a particular component of the CLE requirement in that state that lawyers must meet in some fashion. I don't know what the number is, but they have to take some number of credits in technology-related CLE. Other states like Illinois don't mandate that specifically, but it's certainly a good idea. And we do have CLE requirements, just not the technology one specifically, although it may come in the future. And if it does, again, that should be something that a lawyer should be comfortable with, I hope, because first of all, hopefully they've been doing that all along. But second of all, it's simply a good idea. And there are many, many CLE options that are available through bar associations or through private companies sometimes that offer that kind of insight. And it's a good way to familiarize yourself and get started, particularly if you can find CLEs that touch on not just technology in the abstract, but technology as it relates to your practice area. But another thing I thought of is a little more simplistic maybe, but just if you're on LinkedIn, if you're on Twitter, get started following accounts like the ABA and particularly the Center for Professional Responsibility. And if you do that, you'll find them reposting and retweeting articles and blog posts and other content from people that I would consider real leaders in helping lawyers understand technology. And so you start seeing that content come across your screen more and more, and you can find and gravitate toward the sources that impress you the most and that you find to be the most helpful and thorough. But as you do it, you just sort of, you get in the swim of finding that information, and it comes to you sometimes, and other times you know more about where to go seek it out. Again, it doesn't give you everything you need for compliance with Rule 1.1 in any given case, but it gets you familiar with the programs that are out there, with tools that are out there, with other vendors that are out there. For example, another topic I like to follow through social media and other forums is e-discovery itself. And this is something that I think any litigator should really have on their radar and follow, whether it's your blog, for example, or your Twitter feed, or those of other e-discovery commentators. Again, even if you're not doing e-discovery-based litigation every day, even if you're not in the thick of an e-discovery motion practice or something, it's instructive to follow those feeds. I'm not in the thick of e-discovery myself most of the time. The ARDC practice, which again is the lion's share of the litigation I do, is more paperless than it used to be, but it's still not paperless entirely. And a lot of that is a function of the fact that they have to take in any request for investigation they get in whatever form it comes in, and that's usually paper. And usually when the client is supporting, or the complainant is supporting their version of the story, they're doing it with paper documents. And so the ARDC file is still paper, and they are scanning and they're making it as paperless as it can be, but it's still not entirely electronic venture. And so I'm not always dealing with or engaging the best or highest levels of e-discovery technology, for example. But I still like following information about that in the media if I can, because that gets me aware of what my clients might be dealing with. It helps me be aware of what courts are dealing with. I like to track, and I'm probably the only person in America who says this, but I like to track sanctions cases.
Yeah, I'm sure that's not high up on many attorneys.
No, not number one on the bucket list, I know. But it's instructive, though, for me, because it acquaints me with, first of all, a realm of the practice I don't deal with very much, which is federal litigation. That is, I don't do it. But it gets me acquainted with what the problems and pitfalls are that lawyers face as they go through this, and that in turn will help let you know what technology is available to help avoid those pitfalls. So those were just a few ways I thought of getting started with these things. If that you could join committees in bar associations that deal with law practice management and technology, and they often will present CLEs, as I mentioned, but also it's a way to interact with other lawyers and find out what solutions best work for them. I think in my experience, the right now is the time in history, I think, when lawyers are most willing to talk about their practices and procedures in this way. They're happy to talk about how they use Clio or how they use this or that other management system, or what solutions worked for them and what didn't. And I've been in the practice for 20 years, and it seems to me to be an evolving willingness to talk about that, because the information is out there, and it's good to talk about that with other lawyers. If we can understand each other about what we're doing in these realms, then I think it only helps to advance the profession and our knowledge of what's available to help us.
A couple days before Jim and I sat down to talk, this story hit.
One of the world's largest automakers has agreed to plead guilty to cheating on emissions tests in the U.S. and then scheming to cover it up. Volkswagen has promised to pay billions of dollars in fines. A number of German executives were also indicted on fraud charges. The Justice Department made the sweeping announcement yesterday.
The statement of facts accompanying VW's plea deal revealed that an in-house attorney might have been involved in destruction of some evidence. Obviously something he probably shouldn't have been doing. So I asked Jim, what should an in-house counsel do if they're aware of wrongdoing within their company?
the in-house attorney would have to go up the chain to first a supervising attorney. And for guidance on this, you look to Rule 1.13 of the Rules of Professional Conduct, by the way. But you go up the chain first to that person, the person who is the lawyer supervisor. And in this case, in this semi-hypothetical, it's that person who's doing the wrong thing. Sometimes the rules of professional conduct in a different context call upon the lawyer to remonstrate with a wrongdoer. And this is in Rule 3.3, a client who's testifying falsely or a witness who's testifying falsely. The lawyer must remonstrate with that person. Well, what good is remonstrating going to do practically in this scenario? It's effectively what's required, but nothing's going to come of it because the lawyer supervisor is the one who's saying delete the documents. So in that case, the in-house lawyer has to go up the corporate chain and go to corporate decision makers who are responsible for, in some sense, controlling the lawyer's conduct. Obviously, lawyers, even in-house, act independently and use their professional judgment independently, but practically speaking, there are executives and boards of directors who oversee what the lawyer is doing, and they have to be made aware of the situation. And again, was that practical in this case, given that apparently the executives of VW or they've now admitted to authorizing at least the overall emissions scheme? Perhaps not, but that's the duty, and that's what you do to take it up the ladder.
So that raises an interesting point. Is I understand it, there's some pretty high-level VW execs that are implicated by this. So what do you do in that situation? You're in-house counsel, management isn't listening to you. You take it up the ladder. What do you do then?
Well, that effectively discharges your duty under Rule 1.13. But if you continue to want to be a whistleblower and you believe that the executives and others are committing a crime or some sort of fraud, then Rule 1.6 of the Rules of Professional Conduct allows you to make the information that would otherwise be confidential known to authorities who can rectify the problem. If in the context of the attorney-client privilege, it's known as the crime-fraud exception, but under the rules of professional conduct, it's same basic issue, slightly different contours. But the idea is if someone is causing committing a crime, for example, or engaging in fraud that you know is going to be detrimental to the financial interests of others, then you may. It's not a must, but it's a may. You may reveal that information as part of reporting that conduct.
And that's the threshold, right? The detriment to financial interests of another. So what about a situation where maybe the company's committing fraud, but maybe there's no real detriment to someone's financial interests? Or maybe it's just internal to the company.
You'd have to review the rule really closely in that kind of situation. It still could allow, I think, for some level of disclosure, but it might not, and it seems this is one of those instances in which ethics law can seem a little counterintuitive because when we use the word ethics in particular, don't we think it's ethical to stop wrongdoing? Well, yes, in a broad sense, but it's also in keeping with ethical duties to keep client information confidential under all but a few very limited circumstances. And the circumstances have to be there in order for the lawyer to consider revealing information. And if those circumstances aren't there, then the answer might be that whistleblowing isn't appropriate unless and until the right circumstances arise.
Jim Doppke, thanks for your time. Where can people find you? What's the website?
We are at www.robinsonlawillinois.com, all those words spelled out. And thank you for having me.